MCQ Section 14.1. Litigation. 1. What is litigation? A. A method of negotiation between two parties. B. The use of the court system to resolve disputes. C. A way to settle disputes through private mediation. D. A process of informal discussion between conflicting parties. Answer. B. The use of the court system to resolve disputes. 2. Who resolves issues of law and fact in the litigation process? A. A mediator. B. The parties involved in the dispute. C. A judge or jury. D. A legal advisor. Answer. C. A judge or jury. 3. What is the role of an independent party in litigation? A. To represent one side in the dispute. B. To avoid legal proceedings. C. To resolve issues of law and fact in dispute. D. To negotiate a settlement. Answer. C. To resolve issues of law and fact in dispute. 4. Which of the following statements is true about litigation? A. It does not involve the court system. B. It allows an independent party to make decisions. C. It is always resolved through negotiation. D. It only applies to criminal cases. Answer. B. It allows an independent party to make decisions. 5. What is the primary purpose of litigation? A. To ensure a jury is always involved in disputes. B. To allow the disputing parties to resolve their issues privately. C. To use the court system to resolve legal disagreements. D. To avoid legal consequences. Answer. C. To use the court system to resolve legal disagreements. Advantages of litigation. 1. What is one inherent advantage of litigation? A. It always leads to an out-of-court settlement. B. A court can enforce its own orders and processes. C. It eliminates the need for legal representation. D. It guarantees a quick resolution. Answer. B. A court can enforce its own orders and processes. 2. Why is litigation particularly useful when one party is a reluctant participant? A. It allows them to avoid legal responsibilities. B. The court can enforce its decisions regardless of willingness. C. It enables both parties to negotiate freely. D. It ensures the case never reaches trial. Answer. B. The court can enforce its decisions regardless of willingness. Explanation. Litigation is particularly useful when one party is a reluctant participant because court decisions are legally binding and enforceable. This means that even if one party does not want to cooperate, the court has the authority to compel compliance through orders, judgments, or enforcement mechanisms. 3. Some lawsuits are motivated by a desire to A. Delay the performance of recognized obligations. B. Foster cooperation between parties. C. Reduce legal expenses for both parties. D. Settle disputes without court intervention. Answer. A. Delay the performance of recognized obligations. Explanation. Why option A is correct. A. Delay the performance of recognized obligations. Some people file or continue lawsuits not because they expect to win, but to buy time or avoid doing something they already know they must do, like paying money or delivering goods. This makes litigation a delay tactic, which can slow down the other party's ability to enforce their rights. Why the other options are wrong. B. Foster cooperation between parties. Lawsuits usually make people less cooperative, not more. Litigation is adversarial, each side fights to win, rather than working together. C. Reduce legal expenses for both parties. Litigation normally increases expenses because of court fees, lawyers, and time. It's one of the most expensive dispute resolution methods. D. Settle disputes without court intervention. Litigation is court intervention. The goal of litigation is to let a judge or jury decide, not to settle outside of court. Finally, sometimes a person or company knows they owe money or must do something under a contract. This is what we mean by recognized obligations. But instead of doing it right away, they might start a lawsuit or continue one to buy time. For example, A business knows it must pay a supplier $50,000. Instead of paying, it files a lawsuit to argue about the contract. This delays payment while the case goes through the court system. White right pointing backhand index. So, the real motive behind such a lawsuit isn't to win fairly, it's to delay or postpone doing what they're already supposed to do. In short, some lawsuits are used as a stalling tactic to delay performing duties or paying debts that are already acknowledged. 4. When is litigation sometimes the only option for a party? A. When the other party refuses to cooperate. B. When both parties agree on all terms. C. When legal costs are minimal. D. When disputes are resolved informally. Answer: A. When the other party refuses to cooperate. Note: Summary. Option A, litigation, used when cooperation fails. Option B, mediation settlement, when parties agree. Option D, negotiation, when disputes are settled informally. So yes, your understanding is correct. Explanation. A. When the other party refuses to cooperate. Explanation. Litigation becomes necessary when one party is unwilling to cooperate or refuses to participate in negotiation or mediation. Courts can then force compliance and enforce decisions. Option B. When both parties agree on all terms, this describes a situation more like mediation or settlement, where cooperation already exists. There's no need for litigation if everyone agrees. Option D. When disputes are resolved informally, this reflects negotiation, since negotiation is an informal way of resolving disputes without going to court. Disadvantages of litigation. 1. What is the first major disadvantage of litigation? A. It is always unsuccessful. B. It lacks enforceability. C. It is costly due to legal fees and other expenses. D. It does not require legal representation. Answer: C. It is costly due to legal fees and other expenses. 2. Besides legal costs, what is another significant drawback of litigation? A. The court process is too lenient. B. The case may take years before reaching trial. C. Only businesses can use litigation. D. It guarantees an immediate resolution. Answer: B. The case may take years before reaching trial. 3. How can litigation impact a party's employees? A. It allows them to avoid testifying in court. B. It may take up their work time for extended periods. C. It leads to immediate promotions. D. It reduces their workload significantly. Answer: B. It may take up their work time for extended periods. 4. What is an emotional disadvantage of litigation? A. It reduces stress for both parties. B. It requires little personal investment. C. The emotional and time investment is greater than expected. D. It guarantees an easy resolution. Answer: C. The emotional and time investment is greater than expected.